Hey folks, Mark Scroggins with Scroggins Law Group wanted to remind y'all when I'm answering these questions that y'all have posed, remember that does not create an attorney-client relationship between either myself or Scroggins Law Group and anyone out there. So this is just providing some general thoughts on the questions that y'all pose. I've been told that temporary orders are a prediction of what the judge will do on a final order. Is there a way to overcome this, and can temporary orders be modified? So, two questions there. One, can temporary orders be modified? Yes, they can. The question becomes a lot of the time what county you're in. So easier in Dallas County to modify temporary orders than it is in Collin County, for example, or easier in Denton County than it is in Collin County a lot of the time. Although you're getting more judges that are kind of going with the Collin County model, which is one and done on temporary orders. Now, if you've got significant facts that have changed, most of the time, most counties will allow you to go in and ask for a modification of those temporary orders, but the facts need to be pretty significant. So I'll give you an example of something that would be significant. One of the parties gets arrested for a DWI. More importantly, someone gets arrested for a DWI with a kid in the car. Now, is that going to change the circumstances? Yes, I think that changes the circumstances, and I think that is something where you could end up with a new temporary order. But if it's just something that is rather minor, okay, something that was foreseeable, most of the time the courts are going to look at it like, well, why didn't you bring that up at the time of the previous temporary orders? And a lot of the time they won't do a modification. So what do you do in that situation? You get a trial setting as quickly as you possibly can. That is the quickest way to overcome that. Now, on the other part of the question about is the temporary order a prediction of what things will be on final, kind of, sort of, would be the best way to put that. So like in Collin County, for example, you have a 20-minute per side rule, which, okay, is really abysmal a lot of the time if you've got a number of witnesses, if you've got a big temporary order hearing. If it's just the spouses who are testifying, 20 minutes per side is fine. But let's say that there's significant allegations related to mental health issues and things of that sort, and you've got expert witnesses that need to testify at a temporary order hearing, not just one, but multiple. It's super difficult to get things done in 20 minutes per side, okay? That's one of the benefits of being in some other counties occasionally where you can get more time in that regard, all right? So can you change what the temporary order is at final trial? Absolutely. So let's say, how do you do that? Well, let's say you're wanting to change the child custody portion of the order, okay? Then what are you going to do? Well, you might want to get a parenting facilitator, okay, if it's a high conflict divorce case. You also might want to get a child custody evaluation. Child custody evaluator is going to make recommendations on possession and access for the parties, who's going to have the kids when, and who's going to have what rights and duties. So all of those things can be changed with that. An amicus attorney can do that as well. Maybe you need an attorney ad litem. So there are a whole litany of different things that can be done. But to really go into these in any kind of great detail, it's important to be able to sit down and talk about the facts of your particular case and see what's going to be important.